Hey, folks, let's look into more of the Michigan hyperbaric explosion case, which ended the life of 5-year-old Thomas Cooper in January of 2025. There has been a bunch of hearings. There's been evidentiary hearings. There's been probable cause hearings. And the thing we are going to look into today is some kind of untested evidence. I'm Nick Starow. I am your favorite Viking lawyer, and welcome to the show. All right, here we are.
Now calling case 250000875, State of Michigan versus Gary Markin.
Good afternoon, Your Honor. Danielle Heckman Clark on behalf of people.
Good afternoon, Your Honor. Todd Flood on behalf of Mr. Markin, who's back to my left, along with my colleague. Place your name on the record.
Good afternoon, Your Honor. Hannah Berger on behalf of Mr. Gary Markin.
Thank you. State of Michigan versus Alita Moffett. This is 250000877.
Good afternoon.
Yeah, there's always a presentation of the defendants at the beginning. Just to, it's a roll call. Is everybody here?
So
So they can proceed.
I always do this to you at least once here when we get started, and I won't do it again. 2500878, the State of Michigan versus Jeffrey Mosteller.
Good afternoon, Your Honor. Alana Sharon on behalf of Jeffrey Mosteller, who is present in the courtroom to my left. State your name for the record.
Jeffrey Allen Mosteller. Danielle Heckman Clark for people.
All right, and then 2500876, State of Michigan versus Tamla Peterson.
Your Honor, good afternoon. Tom Cranmer and Gerald Gleason appearing on behalf of Ms. Peterson, who is here in court.
Tamla Peterson.
Thank you. You can be seated, and just for the record, the other day, Ms. Sharon, we really had a hard time catching you if there was an objection or something just from where you're at.
Okay, I'll be louder.
And so there is a microphone that's right there.
At the moment, all of them are out on bail. All of the defendants, there are 4 of them, are house arrest with restrictions. And Tamara Peterson is the CEO and owner of the company whose hyperbaric chamber exploded. And according to the prosecution, because they didn't care about safety measures.
I just think unfortunately we're seated farthest away from it, so I wanted to make sure I brought that up before we got going.
Yes, Judge. Thank you.
Are we ready to pick back up exactly where we left off? I believe we had defense attorneys that had yet to cross-examine Deputy Fire Chief.
Right.
Correct? Are we ready to pick back up?
Yes.
All right.
So this is the fire chief who conducted when there is an explosion, a fire, as in this case, it is the fire department. And in this case, it's this guy who is the central figure, who is the one who is presenting how did it start, why did it start.
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Have a seat.
Thank you, Your Honor. I have no questions of this witness.
Okay.
Thank you so much, Your Honor. I have no questions of this witness.
Okay.
Your Honor, I have no questions for this witness.
All right. Anything for the people then?
I just want to place on the record that, of course, Mr. Kessel, whose witness this is in trial in Third Circuit. And so I am prepared to do brief redirect if the court allows it. I understand that's not typically how we do things with having different prosecutors for different witnesses, but I am here.
Okay.
We have no objection to that.
I have no objection to that as well.
Objection.
All right. Thank you.
Great. Thank you. Good afternoon. Could you tell us your name?
Sean Hug.
Thank you, Mr. Hugg. And you previously testified last Friday about your work and as it relates to this particular case. I have just a few areas that I want to talk to you about. Okay. You indicated on cross-examination that prior to working on this particular case, you did not have any previous experience with hyperbarics. Is that right?
That is correct.
During your review of this case and your determination about cause and origin, did you come to learn about hyperbarics?
I did, yes.
Specifically as it relates to materials that are allowed in hyperbarics, did you learn whether or not there are certain types of materials that are allowed inside of the chamber
Yes,
when it is being used?
yes.
What type of materials are allowed?
Cotton, 100% cotton, or up to a cotton poly blend with no more than 50% polyester.
Do you know why it is those particular materials are allowed inside of the chamber?
Because cotton has a much less potential for developing static electricity through triboelectric charge, through movement or friction.
And in this particular case, is it your understanding, or do you know whether or not Thomas Cooper had clothing on at the time of the explosion?
Yes,
He did.
he did.
And is it your understanding that these particular chambers, can you see into them?
Yes,
And so let me ask you this, in terms of the mattress that people lay on, are you aware of whether or not material is used on those mattresses?
there's typically a sheet placed on the mattress.
And what sort of material is used in that scenario?
It's cotton.
And again, you've indicated that cotton,
Objection. Is he indicating that a cotton sheet was used in this scenario or just generally people use cotton?
I can clarify.
Thank you.
Do you know what kind of sheet was used in this case?
I do not.
Okay. Generally, what kind of material is used?
Objection, relevance. I don't really respectfully, it doesn't matter what generally is done, what matters.
What you have here is a unique thing, since there are 4 defendants. Now, usually, they defend themselves against the prosecutor. In this particular questioning here, it is one defendant's attorney objecting to what another defendant's attorney is asking. Now, it happens, not a lot, but it does happen because every defendant in this case has a different approach to their supposed guilt in this scenario. You have the overarching responsibility of the CEO and owner. You have the maintenance guy, and stuff like that, which may have different types of defense against their own charges. So, which makes this interesting. I almost said funny, but it is interesting.
What happened in this case? And who doesn't know, he doesn't know.
Did you want to respond to the objection?
I think it does matter in terms of what's allowed within these chambers. If the argument is that material to material is what potentially caused this explosion, then I want to talk about that. And if that's truly the case, why aren't we having more explosions? That's what I'm getting into.
Your Honor, she's already asked him what's allowed. I have no problem, I don't think any of us do, with her asking what's allowed. But in terms of if he doesn't know what was actually used in this case, I think any additional line of questioning is inappropriate because he can't testify to what was in the chamber.
What seems
Is
to
this an
be
issue where he
what seems to be happening here is that, as this attorney, one of the attorneys said, well, weren't there more explosions? Well, now she's asking him almost as if he's there as an expert witness, not a fact witness, which makes this line of questioning odd. But let's listen to what the judge says.
doesn't know what the material was that was used in the chamber, or that they use in the chamber, or he doesn't recall?
Well, let me ask you this. Do you know what's typically used in chambers?
Objection, I've already.
That was the objection.
Okay.
I just want to break this down. So he had previously just testified that he learned the types of materials that were typically used in the chambers. That was part of his research and what he learned in investigating this. He just testified to the materials that were preferred.
So those are two different things, right? The question he was asked is, did he know what materials are allowed? I have no problem in testifying to that, and I think it's probably contained in all the exhibits that have been admitted.
Certainly.
But to then go further and ask him what was in the chamber, I have no problem with that question either. But once he says, I don't know, anything past that is irrelevant.
If it's the testimony that he doesn't know, in this particular case, what the material was, I don't know that he'd be able to continue to answer questions on that issue.
Fair enough, I'll move on. Is cotton an insulator, a conductor, or something else?
Cotton is an insulator.
What does that mean?
It means it does not freely allow electrons to move across its surface or to another surface.
And I think we've heard testimony previously that static electricity always goes to ground.
That is correct.
What about human beings? Are they conductors, insulators, or something else?
Human beings are conductors.
So what does that mean?
It means that they will receive the charge and will pass it to ground upon contact.
Are you familiar with NFP 921?
I am, yes.
What is it?
It is the guide to fire and explosion investigations.
And are you specifically familiar with 19.4?
I am, yes.
What is that?
It is the section on data analysis.
What does it say about data analysis?
It states that the investigator must utilize his knowledge, experience, and training in the analysis of data or facts that are gathered throughout the course of the investigation. And if the investigator does not have the knowledge or experience, that they may reach out or utilize that of experts in that field.
Did you do that in this case?
I did, yes.
And who were the experts that you reached out to or relied upon?
I utilized the reports that were submitted by Mr. Berman and Mr. Melenchenko.
NFP 99, specifically section 14.3.1.6.3.2, does it talk about the use of a grounding strap?
It does, yes.
And what does it say?
It states that any operations in an atmosphere above 23.1% shall require the use of a high impedance patient grounding strap affixed to the patient's skin.
Does it say may?
No, it says shall.
In your expert opinion, would the use of a grounding strap have reduced the likelihood of ignition in this case?
I believe so, yes.
Why?
Okay, my apologies. It seems like he is actually there as an expert witness as well as a fact witness. I find this, as per usual, extremely weird. I've encountered that in other trials. I think it's weird. I think it shouldn't be allowed to use the same witness as both a fact witness and an expert witness, because it's self-bolstering.
Because through the use of a grounding strap on the patient, he would have been at the same electric potential as all the other conductors within the chamber, and therefore would not have created a differential in potential should he become charged with static electricity, generating a static electric current.
Thank you.
Anything else for this witness from any of the defense attorneys?
Can you give us 1 minute?
I can, of course.
Thank you.
Okay, let's skip ahead.
1 moment. If you
Of course.
Afternoon. Chief, good afternoon.
Good afternoon.
Chief, just to be clear, you're not changing or disavowing any of the answers you gave me to my questions on Friday, are you?
I do not believe so.
Okay. You understood my questions?
I believe so.
And you answered the questions truthfully and to the best of your knowledge and ability, right?
Yes, sir.
Since your testimony on Friday, have you talked to anybody about your testimony?
Nobody involved with the case.
Okay. you had no contact with anyone from the prosecution team from Friday until right now?
Not after Friday afternoon, no.
How about when you say Friday afternoon, does that include time after your testimony?
Yes,
It does.
yes.
Okay. So just to be clear, so I'm clear. Once you left the witness stand on Friday until now, you haven't talked to anyone from the prosecution team. Is that true?
No, afterwards I did talk with Mr. Kessel,
Oh, you did? And what did you talk about?
just about coming back today.
Uh-huh. And did you talk about ways to improve your testimony?
I did not.
Did you talk about anything substantive regarding the case?
I did not.
You just talked about logistics?
It was logistics, and he stated that if he had any other information that might be pertinent to my way of testifying as to my speech or the way I articulate myself, he would let me know, but I have not heard from him since Friday afternoon.
All right. Were you asked to review any materials in connection with your continued testimony?
I was not asked to, no.
Did you do that?
I did, yes.
What did you do?
I did a little bit of Google researching. I went back through
Oh
921.
no.
I reviewed NFK 99. I reviewed my report.
Okay. And did that help or assist you?
It did, yes.
Okay. And we talked a little bit about, I believe Ms. Hagman Clark did, asked you a little bit about 921 and section 19.4, right?
Yes,
And that's the section that talks about analyzing data, right?
yes,
And that section clearly and unequivocally says that in reaching a conclusion, you have to analyze all the data, right?
yes,
And you haven't done that in this case, have you, sir?
that is correct.
So because you haven't,
Oh. Oh, fire chief. This is an important case involving the death of a 5-year-old boy who was in so-called treatment for sleep apnea and ADD via an hyperbaric chamber. Now, this has no medical evidence of working. At best, it's temporary relief because a hyperbaric chamber works that they pump in 100% oxygen and then pressurize it. A hyperbaric chamber, to be clearer, is what is diving sickness is treated with. If you ascend too fast, you depressurize too fast, and it screws up the blood vessels and stuff. So you have to repressurize and then slowly bring you back up to surface level. So this is what they are using apparently to treat ADD and sleep apnea, which may temporarily give some relief because they are forcing in oxygen into your body. And Thomas Cooper, age 5, was in such a hyperbaric chamber when it exploded, burning him outside and inside. His mother got severe burns on her arms and upper body as she tried to save her son. So, listening to this fire chief not conducting his investigation properly, seriously, a child is dead. Take it serious.
analyzed all the data in this case, you can't possibly have come to a final conclusion about the origin cause of this fire. Isn't that true, Chief?
Through the utilization of the expert testimony, or the expert reports, and the video in which I reviewed, and the information that I have come to that conclusion, yes.
Well, Chief, you're going to have to help me with that. Because in June and July of 2025, you met with interested parties to gather more information about your investigation, right?
Correct,
And interested parties, as we talked about, is a term of art, isn't it?
yes,
Interested parties refers to all of the people who might have an interest in the origin and cause of the fire, right?
correct,
In this instance, it's people on what I'll call the civil side of the case, right?
yes.
People who aren't really in this room, true?
There were representatives from the site there.
That wasn't a very good question. But that's a separate kind of side of this case, the civil side, true?
Yes, sir.
But there's also the criminal side, and the defendants, they're interested parties, right?
Yes, sir.
And the reason that you got together with the interested parties back in June and July of 2025 is to collectively discuss how this fire ought to be investigated, right?
Correct,
And the idea of doing that, and what 921 tells us and teaches us, is that it's better to get all the people involved together at the same time and essentially conduct one investigation, so you don't have people going in different directions, taking this piece of evidence or destroying that piece of evidence. Everybody's kind of together, right?
yes, sir.
You gathered that information, right, in conjunction with all the interested parties, right?
Yes,
And you haven't analyzed what you gathered. Isn't that true?
specifically, that is correct.
And we talked last Friday about one of the things you haven't done is you haven't analyzed any sample that might be taken from the oxygen tank, right?
That is correct.
And it might be, we don't know because you haven't done it yet. It might be that that investigation turns out that there was some impurity in the oxygen, which could have been a contributing cause to the fire, true?
I utilized the expert report, who is an expert in the field of hyperbarics and mechanical engineering, who stated that there were no observable evidence of any type of flow-rated ignition.
All right. And I appreciate that, but you got to listen to my question. Here's my question. The fact is that you haven't yet analyzed any sample that might come from the oxygen tank to see whether or not there may have been some impurity in the oxygen tank, right? You haven't done that.
That is correct.
And I think you told us on Friday that that's a potential issue in this case, isn't it?
I did on Friday, yes.
Okay. You're not changing that now, are you?
As I went back and reread my report, Mr. Berman's expert report stated about the no observable.
All right. But Chief, let's be candid here. Mr. Berman didn't test the sample from the oxygen tank either, so he couldn't possibly have come to any conclusion about that, right?
It calls for speculation.
Oh,
What
no.
Berman is, I'm sorry, let me finish, please. What Berman is able to do with his report, he was subject to cross-examination on, and if that was a question, that should be a question for him. The questions that he's able to answer is what he relied upon to come to his cause and origin expert opinion. So this is outside, and it calls for speculation about what Berman can or can't do.
No, with all due respect, it does not call for any speculation. He can certainly testify as to whether or not, to the best of his knowledge, Mr. Berman has tested any sample from the oxygen tank. That's the question.
All right, I think that's clearer than the original question, but if that's the question in its entirety, then I think he can answer it. He knows.
All right, and I'll apologize for the imprecision of my earlier question. So you heard the judge's question?
Yes.
Can you answer?
To my knowledge, it was not tested.
All right. Okay.
One of the things that I really, really dislike is sloppy investigations. Why on God's green earth would you not test these things? Why? A child is dead through, according to the prosecution, neglect, incompetence, And by not using the grounding bracelet, which caused a spark. Now, even if it seems insignificant, test it. It really isn't that hard, because now all of a sudden it gives an opening for the people who should be held responsible. Now, again, folks, innocent until proven guilty in a court of law. And if the investigation is shabby and they don't test things they should do, it really doesn't matter. Because if it's done to to a certain extent, that it becomes incompetence of the investigators. Even if we believe the person is guilty, they should walk. So we shouldn't blame the defense for asking these questions. We should ask ourselves, why in the flaming blue balls of hell wouldn't you test these obvious things?
And Chief, you stand by the fact, do you not, that you can't rule out fabric to fabric static as a cause of this fire, right?
With absolute certainty, no, I cannot.
Okay. All right. I have no further questions. Thank you.
Sorry.
Okay, let's see here if there is any additional questions.
Good afternoon. How are you?
Good afternoon.
I have just maybe one or two questions. Have you ever heard the name Tom or Thomas Fox?
I have, yes.
Okay. Have you ever spoken with him?
I have not.
Okay. Did you at any point during your investigation know that he had been interviewed by Detective Yunkari?
I did not.
Did you at any time during your investigation know that he had expressed an opinion that wristbands were not needed?
I did not.
If you would have known that, what would you have done with that information?
It would have been included in my report and utilized in the overall formulation of an opinion.
Would you have been obligated to speak with him and investigate his opinions to see if they had merit?
As I did with Mr. Berman and Mr. Melenchenko, depends on the medium in which I received the information.
The last time you were here, you talked about the scientific method and your obligations to not be biased. Do you remember all of that?
Yes.
Okay. Would you have an obligation if it was made known to you that there was an adverse expert opinion to Berman and Melnichenko to interview that person?
Yes,
And obviously that didn't happen here. Is that correct?
that is correct.
That's all you are. Thank you.
Okay. Do you have anything else for this witness?
I don't.
Great. Thank you. You can step down.
Folks, it seems like the investigators have taken a few shortcuts. Now, I have a bunch of videos and streams about the Michigan Hyperbaric chamber explosion case. So it should not come as a surprise, my opinion, that the responsible people for this screw-up is one or more of the people who are charged. But I'm also have to hold the prosecution and the investigators responsible for screw-ups. And it seems like with this fire chief, they took shortcuts. Again, a child is dead. And this is one of the times you should never take shortcuts in an investigation. Well, generally, it should never happen with that you take shortcuts, because with a competent
And say you don't
with competent defense, they should and have an obligation to exploit that, which they do here.
have another witness.
No,
Your Honor, if we could speak to the missing witness. I think this is the third day that he's not appeared.
Oh, no, because I was under the impression that this witness was gonna take the afternoon, and we specifically talked about the last witness having a different day, but I don't wanna say I was misled, but I clearly didn't have the information that would lead me to believe we'd be done by 1:30.
I'm speaking of the prior dates that he did not appear. He's not appeared on prior occasions, and more so to guarantee that is he going to appear at a future date.
that to me, that's my problem, not theirs, right? Like he's my witness. He's
Do
gonna
you
be
wanna
here.
talk about this on the record? If you do, I don't have an issue if you wanna come to the microphone and we can talk about it, because I think it's probably best that we come up with a plan here.
All right, they had a sidebar. What is
Thank you for the
missing
opportunity to
witness?
address, where we go next with this case at the bench. We did talk about scheduling, and, although I had underestimated how quickly we were gonna wrap up with the witness today, I do recall that, there was not an order for the people to have the next witness, because I thought we would take a little bit longer through the afternoon. So at this point, taking into consideration what I believe will be the time needed to finish the testimony in this case, all of the attorneys that are working on the case, except for Mr. Kessel, who will be notified of the new date shortly here. Everyone's coming back January 12th in the morning, 9 a.m., potentially the 13th. The remaining witnesses that we anticipate for the people witness, I should say, plus any potential witnesses that the defendants may like to call or recall.
Yeah, and the rest here is scheduling. Folks, I'm going to keep covering this particular case because it's important. A child is dead due to screw-ups from the owner, CEO of the Hyperbaric chamber treatment facility. But you have to prove it beyond a reasonable doubt. Taking these shortcuts it's a spit in the face of the victim. We have to hold prosecutors and investigators to a high standard. Don't take shortcuts. All right, folks. That is what I had for you for this event. There are more witnesses that I haven't gone through yet, and I will get to them eventually. But this case will probably not get to trial in the first half of 2026. We are maybe fall of 2026, maybe even early 2027. But folks, you know what to do. Leave a comment, like, subscribe if you haven't. And I will see you all in the next stream or video. Bye-bye.